disappear below the...
The soda. Okay.
Worship, I have the spelling of the name. It's S-I-X-O. I-X-O, the first name. And her surname is G-C-R-L-I-S-H-E. It's a VFF live streaming. Thank you.
Oh, thank you. Does anyone have any objection? First read out the media houses, including your name. Then just hear if anyone has any problem with the media claim. Firstly, there's Ronald Masinda on behalf of ENCA. Sipabalwa Mukana. Ndena, I can't say Ndena. Also from ENCA, there's Sipo Lema, New Zealand, Africa. Sia Bonga and Kayana, New Zealand, Africa. Yampelo, Mutsinyo.
Pumakapa TV.
Do I acknowledge them? Duma Deniso, also Pumakapa. Then is Titandiwe Elaku, News 24. There was an application, formal application by SABC. But the person have been given Yankees plus 2 others were listed. And then the last stream of the EFF, which will be dealt with by SECO and Risha.
As worship, please.
Everyone's concerned except that.
We accept. We do worship.
Thank you. I reminded you people and we've gone over the rules of do and the don'ts. Please abide by it and so we can proceed. Thank you. So you're calling the witness?
I'm calling the witness.
Your full name, please?
Martin John Hood.
Good.
Hood, H, Your Worship.
Good.
Hood.
Do you have any objection in taking a prescribed oath?
No.
Do you then swear that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Mr. Wood, since you will need interpretation in the matter, up to 5 English,
Not from our client, worship.
Advocate Matthew.
We can proceed to us for that interpretation. I don't know whether there are people in the crowd who might like one to hear. But
What hour is it?
not for the accused, we don't require.
Mr. Wood, please keep in mind that I'm writing down your evidence. So after the sentence, you'll just pause for a second or so, so that you start with what you want us to find out.
Yes, Your Worship.
Thank you.
Thank you, Richard. Mr. Is it correct that you are an expert in the Firearms Control Act 60 of 2000 as amended?
I was admitted as an attorney in 1990. I practiced continuously since then. In 1997, I was invited by the South African Police Services to be part of the consultative process for the drafting of what became the Firearms Control Act on behalf of the South African Gun Owners Association, of which I was also the vice chairperson at the time. From 1997 until when the Act was passed in Parliament in 2000, I was part of the process of consultation where the Act went through numerous drafts, and I made a presentation both personally and on behalf of the South African Gun Owners Association to Parliament in 2000. Concerning the structure and the content of the Act. From 2000 to 2004, I was part of the civilian component that helped draft the regulations to support the Act. Where I worked closely with the South African Police Services, legal services. From when the Act was promulgated in July of 2004, I've been involved in numerous processes concerning the Act. Most recently in May of 2023, my apologies, Your Worship. Numerous processes, both judicial and parliamentary. The most recent of which was that I made a presentation to Parliament in May of last year to the Portfolio Committee on Police on behalf of the South African Arms and Ammunition Dealers Association, where the Minister, Deputy Minister, National Commissioner and various other senior police officers were present. I did that at the request of the chairperson of the Portfolio Committee. I was also a panelist Firearm Summit held in 2015 in Parliament by the Portfolio Committee on Police.
Correct to say that you represent the security industry?
Yes.
We are concerned in this particular matter with tactical security services situated in the Plattelanders. Are you aware of this company?
I am.
Have you had dealings with this company?
Part of my practice involves the obtaining of firearm licenses for security service providers. And in that capacity, I have made applications, prepared applications on behalf of tactical security services.
Would you say that you are, sorry,
What notes are you running the new form? Just a second,
sorry.
I have prepared the
Firearm license applications.
on behalf of that.
Correct.
If you could just, in broad outline before we deal with the specific matter, explain to the court how a security company would go about obtaining firearms for their security guards and the procedures that are used. If it is that simple.
Once a company is registered with the Private Security Industry Regulatory Authority, SIRA, it is automatically accredited to own firearms. That company must nominate to the police a person who is responsible
We can simply refer to the evidence of a Mr. Stander who has testified. But we can simply refer to the evidence of a Mr. Stander who has testified for the state from Sierra, as indicated in his testimony, as well as the evidence of Lieutenant Colonel Janssen, that the person appointed or the responsible person for tactical security services was Mr. Clement Ndluli.
I checked my records personally, and Mr. Ndluli was the responsible person according to the documentation that I prepared in 2018, and he was also the member of the closed corporation in 2018.
Tactical security services was a closed corporation. Right?
Correct.
You use it loosely as saying it was a company, but that's not 100% correct.
Yes.
Mr. Ndluli, Clement Ndluli, he was, I suppose, the majority holder, if you call it that, of the closed corporation.
I don't know what his membership was, but he signed the application in his capacity as the member.
Now, let's follow the procedure that would now happen. You say that once a company like this or a closed corporation is registered with Sierra, it automatically becomes entitled to acquire firearms.
The word is accredited, yes.
Accredited. We have heard the evidence of Mr. Stander that tactical security was in fact accredited. And I'm sure you picked that up during your application for firearms on them.
They had to be because they were granted firearm licenses. Their licenses were approved. So they had to be compliant with that accreditation.
We also had the evidence of Lieutenant Colonel Janssen about an inspection done at Tactical Security, about the books that were kept and all the registers that are required to be kept by a company, or let's keep using the word company like that. You're aware of that?
I'm not aware of the specific inspection, but police regularly inspect the books.
Now, I am the new security guard, and Tactical Security now wants to arm me because I'm going to be guarding an ATM. I want you to tell us the steps that need to be taken and the permissions, etc., and who is responsible for the firearm that I'm eventually got now in my possession.
The individual security officer has to be registered with CIRA, the regulator. They must have a competency certificate to possess a firearm. They must have completed additional training known as the business purposes training. In order that a firearm be given to that security officer, he must be in the employ or service of the license holder. The responsible person or someone delegated by the responsible person signs the firearm over to the security officer by way of an entry, a written entry into a daily working firearm register. The security officer co-signs that they received a firearm, and then the security officer is issued a permit by the responsible person or someone delegated by the responsible person, which is a temporary license in effect, to possess that firearm on the conditions, according to the conditions stated on the permit.
I'll show you a document dated the 13th of March 2018 from the South African Police.
I note it.
March 2018, but was there a date?
It's dated 13/3/2018. I will, unfortunately, I've asked for it back because we were on our way to make copies of it.
You want it on the copy?
I will read it into the record. I think that's the easiest.
So I can write as fast as you do.
No, I'll read the first two lines because that's what is of relevance there. It says the responsible, this is a warrant officer, A.M. Small from Brighton Beach, designated firearms officer. I will also show my learned friend the document. It says the responsible person for the safe handling and proper handling of firearms is Mr. T.C. Mzuli with ID number 7603215498084. Who is in possession of a relevant and valid competency certificate to handle and use all categories of firearms in possession of the above security company. You read this?
I have.
Does this coincides with the evidence or corroborates the evidence of Lieutenant Colonel Janssen, who was the responsible person for firearm compliance and tactical security? No.
If I may just put that slightly differently, Your Worship. If that were not correct, tactical security would not have been granted the firearm licenses in 2018.
Why we are going through this exercise is because of the provisions of section 120.10a of the Firearms Control Act, which is count 6 in this matter. And this section, the charge against accused number 2, and I'll read it to you. It says that on about the 28th of July 2018, at or near the Caesar de Casa Stadium in Mdantsane, the accused had unlawfully supplied or in any other manner give possession of a firearm and or ammunition to wit a .223 Noriko rifle and or a firearm the make of unknown to the state and a .223 Remington bullet to Julius Malema, accused number 1. Now, what is important here is this section. Did unlawfully supply or in any other manner give possession of a firearm. Now, if I could just, before you apply to this, tell you that in a request for further particulars, the state was asked in what manner it alleged that the accused handed a firearm to Julius Malema. And the answer was, I will read it to you. Where you need to find the right place. Okay, got it. The state's reply was, the cartridge found on the site after the event of the 28th of July 2018 was fired from the rifle serial number SPA 249. The state alleges that the rifle was handed to Mr. Malema by accused number 2. You understand? That is what the further particulars say. When I last looked at the law, the state is bound by that answer. But in any event, I want you to comment on the provisions of section 20 to 120 of the Firearms Control Act of if there is no evidence that he physically handed the firearm to you, this phrase in any other manner gives possession of the firearm.
So,
And how far back are we going? Are we going back to the manufacturer in Marine?
Your Worship, first of all, I think it's subsection 10, bracket small a.
Yes.
Yes. Firstly, there is no definition in the Act of supply or possess. I've just checked that as you were asking the question. To give an absurd example, if I may, and speaking from experience, if one had to take a large security company that has many thousands of firearms, and there are quite a number of such security companies, to use this section, well, I have never seen this section used in my experience over 20 years to charge the owner or even the responsible person with such an offense. What almost invariably in my experience would happen is that the point of contact between the police and the license holder would be the responsible person. One of the primary functions of the responsible person is the keeping of up-to-date and accurate records. Excuse me. And there are registers specified in the regulations and how they are to be maintained. The police would then inspect those records and go through the chain of possession or use that those records specify. And they would then go to the person whomsoever those records specify as the last person who used or possessed that firearm. And then it is that person that is either asked to provide a statement or is charged with an alleged offense. And if I can just take it one step further, I've acted for many large security companies, and I cannot recall where the owner, the owner or director has been charged with this type of offense.
Let's use an third example. Fidelity, probably got hundreds, thousands of cars. Who knows how many firearms? Any one of those guards does something wrong, the owner will be charged because he, in some or other manner, gave possession of the firearm to the guard.
Well, that's the absurdity that I'm referring to.
And anyway, the Firearms Control Act makes provision, does it not, for a person who has a license for the firearm to hand it to somebody who doesn't have that?
Yes, there's a number of reasons for that. I think it's section 22. Yeah, section 22 of the Act. And, Your Worship, to give a simple example, if I may, the Act provides for this simply because for a person to obtain a competency certificate, they are obligated to handle and discharge a firearm. So you can't use and possess a firearm without a competency certificate. But in order, for example, to be trained, the training provider allows you to use their firearm under their supervision and control. That's the requirement of the Act. And there are many other examples where that would happen. For example, on a shooting range where someone wants to test fire a firearm, that is specifically provided for in the Act. It's called demonstration and display. Where someone wants to engage in a sports shooting competition, for example, many shooting associations provide firearms for that purpose, and they're used under the supervision and control of an official from that body. And a simple example, which is a fairly common example as well, is if someone wants to go hunting, they use somebody else's rifle in their presence and control when they go hunting. It's very common.
Now, we apply what you regard as your testimony to this particular matter. And I must add from the outset that we will be comprehensive to ballistic evidence to show that the firearm in question did not fire the cartridge shell. So what I'm now putting to you is based on the premise that the state's evidence led so far is correct. You understand?
I do.
This particular firearm, according to all the records, was under and Lieutenant Colonel Jansen, who did a inspection, was in the possession of a person, I'll call him Mr. L.M., a security guard employed by technical security company. So, you understand that?
I do. It was signed out to him, in other words.
It was signed out to him. Mr. Nduli was the responsible person at the time. That is not only that document I showed you, but also the evidence of Lieutenant Colonel Jansen. Now, who would be the responsible person for this particular firearm?
Your Worship, we need to draw a distinction between responsible person as contemplated by the Act, which is a specific individual, and who is responsible for the firearm, which is different.
Okay.
So the person who is responsible for the firearm would be the person to whom it was signed out from the daily working register, and who had the temporary authorization to possess that company firearm. That is the person that the police ordinarily, and in my experience almost invariably, would hold accountable for any misuse of that specific firearm. And I would like to add as well, bearing in mind that I was involved in the genesis of the Act, that was always one of the principal purposes of what became Regulation 21 of the Firearms Control Act, which is intended to enable the police or a regulator to ascertain who had possession and use of a particular firearm at a particular time.
You said there were two scenarios.
Well, the responsible person being the one in the police records, and then the person who is responsible. I'm speaking about the person who is responsible, not the responsible person.
Do you think under these circumstances, if I may ask you this, if you don't want to answer them, say Mr. LM did something with a firearm, fired a shot at his girlfriend in anger, do you think Mr. Julius would be held responsible in law for that?
I think I've answered that. I've said that the starting point for an investigation would be to go to the responsible person. But then that the records that are required to be kept in terms of Regulation 21 and Regulation 22 show the chain of possession and custody, and ultimately the individual security officer would be held accountable.
Is that the purpose of these regulations?
Absolutely. And I want to emphasize that, again, in my experience, where I have conducted many criminal trials, I've represented accused based upon an offence committed with a business firearm. It is the security officer who had possession that is charged. The only time a responsible person might be charged would be if there is improper record keeping in some way, and then that is covered by Section 122, I think it is, which deals with administrative fines. So in other words, it's an administrative issue, not a criminal issue.
You have read the ruling in terms of the Section 174 application before this court, is that correct?
I have.
Of course, worship is only entitled to, is a discretionary matter, to use the 174 so desire. But I want you to comment on this ruling by the court in terms of what Section 174, if you are able to. If you don't want to, just comment.
Would you like to read me the part, please?
I'll read it to you. It says it comes, I'm reading from page 26 of your worship's ruling, from line 17. It says it comes down to the fact that count 4 and count 6 remain a statutory offence. It was confirmed in the evidence so far presented by the state that the firearm in question, being SPA 249/14, is indeed your firearm or the company's firearm, then inaudible, I should put it in that manner. The cartridge that was picked up at the scene or close to the stage or after the incident is linked with microscopic ballistic analysis to SPA 249/14. Much emphasis was placed on the fact that none of the videos or witnesses testified that they saw you, speaking whatever, is you now handing a firearm to Mr. Malema, but that is not the charge. The charge is, and I will read it for clarity, it is much wider. It is unlawful supply or in any other manner give possession of a firearm or ammunition. Being the Narinka firearm and a Remington bullet to accused number one, so the actual not seeing or handing over is not a requirement in terms of section count 6. It is supply or in other manner give possession.
With respect, Your Worship, first of all, the firearm could never have belonged to an individual for two reasons. The first is that the license holder is Tactical Security Services. And that is a separate legal entity to any other corporate or individual person. Secondly, it goes back again, and Your Worship, I say this with respect, to the absurdity of the interpretation of the Act, because it seems so literal and so strict that you could say that the manufacturer could be held liable for making and supplying the firearm to a wholesaler who sold it to a retailer who sold it to a company or an individual. That is not the purpose, in my opinion, or the intent of the legislation. And I've never seen such a charge. I said earlier, I've never seen such a charge other than in circumstances where there was some form of direct interaction between the parties.
If I may move on to what is termed a blank gun. Sorry, you might confirm with Is it, I'll ask you this, is it correct that you were shown we were probably having difficulty with bringing this into the court premise? We'll see if we can, we had that agreement that the worship will recall that if we wanted to bring any firearm in, we would notify everybody before the time. You were shown a firearm, is it correct, what's this? Called a blank gun.
I've seen many blank guns. I haven't been shown specifically one for this matter.
Oh, sorry, I thought they'd shown
No, I haven't.
That'd be kind of correct. These blank guns, are they required to be licensed?
I'm going to say a very simple no, Your Worship, because they are sold without licenses, and the National Prosecuting Authority and the police accept that such sale and possession is lawful.
You are aware of a document from the National Director of Public Prosecutions, I think Advocate
The cock.
de Kock is the author thereof, in which he notifies the police that no prosecutions must take place for these firearms.
That's correct. I'm aware of it. If I can just add as well that it follows that the possession of the ammunition used in those blank guns is lawful as well.
Well, we have a ballistic expert that's going to testify about this particular gun. I would have liked to have shown it to you, but we will leave it at that if it becomes necessary during the cross-examination or the re-examination. I will ensure that I get permission to bring it in here because it's going to be obvious to everybody that one cannot distinguish between the real one and the blank.
Your Worship, as I indicated, I've seen a number of blank firing objects and their ammunition. And although I'm not a ballistic expert, I own a large number of firearms. I'm an enthusiastic shooter and firearm collector, and I cannot distinguish between a blank firing object and a real firearm. They're in fact designed both in terms of appearance and their mechanical working abilities to be exactly the same as a real licensable firearm.
Thank you, Mr. Butler. Sorry, just one further question. My colleague just pointed out. Were you aware that Mr. Snyman was not a member of Tactical Security Services in 2018?
I've checked my records, and the member was Clement Nduli.
Thank you. Sorry, could I just approach the accuser's podium? Apologize. Sorry, I forgot to apologize for the accused being late. They had in fact gone to a different court. But please want me to apologize on their behalf.
Thank you. Affidavits, cross-examination.
They are first one, sister. She's not there. I have no questions for this witness.
Exhibit Caesar, cross-examination.
May
Wait
I,
a minute.
yes, Your Worship, may I just request a brief adjournment? One, I want to make a copy of the document that was at the Matthew's disposal for all the parties involved. Number two as well, I just want to also make a copy of the document they referred to about the NPA Advocate de Cox draft. I do have it in my possession. I'll just make copies for everyone. So the adjournment will be Half an hour, Your Worship?
Half an hour.
Quarter to?
It's up to you. I'm in my office, available, ready.
Yes, Your Worship. What we will do as soon as I'm done, remember, I might struggle to make copies here. As soon as I'm done, I'll call Your Worship.
Please don't call me, ask the police officer to call me.
Okay, I mean, actually,
I know what you mean.
Yes, Your Worship.
The matter will then stand down for that purpose and just call me at any stage when you are. Thank you.
Right.
We have H. Yeah, I see H, and I was Steenkamp. J was also Steenkamp, Governor K1 and up to K2. L. Yes, so I'll mark it as exhibit L and L1.
Yes, so you want L1 and L1 to be the firearm compliance,
Yes.
small, and L2 the cost. And then
Control Act, which I might add, the version you have there is outdated.
Thank you. Your evidence only here to assist the court today in the interpretation, section 120, subsection 10A. Is that correct?
No,
What is the purpose of your evidence today?
I've given evidence about the provisions of Regulation 21 and 22.
You referred to section 120, subsection 10, is that correct?
I beg your pardon?
You were referred to that particular section.
Subsection 10,
That's correct.
small a, yes?
That's correct.
Yes.
Can you read it out loudly?
You want me to read it?
Yes, please.
It is an offence to, and then brackets A, sell, supply, or in any other manner give possession of a firearm or ammunition to a person who is not allowed, in terms of this Act, to possess that firearm or ammunition.
What is your understanding of that particular section as you've just read it to court?
Well, I think first of all that it's a very broad and very section of firearms and ammunition, which has got its own set of regulations in order that you may sell or dispose of a firearm. Supply is another very broad word which is not defined in the Act. And then in any other manner give possession. Possession is also not defined in the Act. So it's a very broad, possibly quite vague provision of the legislation.
As it stands here in its simplest form, what do you understand from it?
What do I understand
Yes.
from it? Sorry, you're going to have to contextualize it because
Yes.
it's got so many different meanings.
Yes, it says that it's an offense to supply or in any manner possession of a firearm or ammunition to a person who is not allowed in terms of this Act to possess their firearm or ammunition.
So there are, by way of example, there are numerous disqualifications contained in the Act that prevent a person from possessing a firearm. So you need to put to me, with respect, an example of what you are talking about, and then I'll gladly comment on it. Like I said, this is so broad that you can't just say, what does it mean? It's applicable to a variety, a large variety of different situations.
To me, it looks pretty simple. I want to put it to you, to me, it looks so very simple. It says that you are not allowed, in this offense, to sell, supply, in any other manner, give possession. In any other manner, give possession. It's very simple. I don't understand what you mean when you say it's very broad.
I don't want to argue with you, but you should read the whole section, because it says, to a person who is not allowed in terms of the Act to possess a firearm. You can't quote a part of the section. You've got to look at the entirety of the section.
Yes, I understand that.
But
It's
that's
still
not what
very
you're
simple
putting
to me. It's still very simple to me that it's a person who's not allowed to possess this particular firearm shouldn't be possessing that. Is that correct?
A person who's not allowed to possess a firearm shouldn't possess a firearm, correct?
You said earlier that you were involved in drafting this legislation, so I want to know what was the purpose of putting this particular section into the Act?
I was involved in the process of consultation on the Act. I can't speak as to a specific purpose for a specific section because I did not draft the Act. I was consulted on the Act.
Were you aware of this particular section that is in the Act?
Yes?
And what was your view of this particular section when you saw it there?
I can't remember. It was 27 years ago.
As a matter of fact, as I understand it, that it is indeed an offense to allow a person who is not in possession of a particular license or competency to have a firearm in his possession. Is that correct?
No, you're incorrect.
You explain to me.
Section 22 permits it. Regulation 21 permits it. And there are probably other examples if I had to apply my mind to it. There's also provision, it's called an SAP 539, which is contained in Regulation 86 for the storage and possession of somebody else's firearm. That's examples that come to hand, immediately come to hand.
You said you've never in your career seen this type of charge in your 20 years. Is that correct?
No, I didn't say that.
What did you say?
I said that in my experience, I've never seen this section applied to the owner or a responsible person of a security company.
But have you ever seen anybody being charged under this particular section?
Not that I can immediately recollect, but that doesn't mean to say that it hasn't happened.
You also made an example earlier that you've never seen this particular section being applied. Then you also said that there must be a direct interaction between the parties. I don't know whether I recorded your answer correctly, but can you just explain what did you mean if you say there must be a direct interaction?
I'm not quite sure what part of my evidence you're talking about, so I'm not sure what you're referring to. What I meant was, when you give possession, you can do it in a number of different ways. So you can hand it to somebody, or you can allow them to access it. But possession is not defined in the Act.
If I give you a scenario that, for example, say accused number 1 fired shots in the air with a particular semi-automatic rifle that was provided by accused number 2, would this offense then be, this particular section then be applicable in those instances?
Well, you're not giving me facts, so I can't comment. I don't know what the facts.
That is, he's putting facts to you.
So you're saying that accused number 2 gave accused number 1 a firearm?
That's correct. To fire shots in the air at a particular stadium here in East London.
Okay, but please bear in mind, as I've pointed out, this section is not that simple, because it says who is not allowed in terms of this Act to possess a firearm. Mr. Malema, as I understand, accused number 1, is not unfit to possess a firearm. So he's not allowed in terms of this, he's not disqualified in terms of the Act from possessing a firearm.
I don't know if I understand your answer properly.
I can give my firearm to you in my presence. That's not an offense, unless you have been declared unfit to possess a firearm.
But can you give your firearm to this particular person knowing that he's about to commit an offense when you are present and he commits an offense?
Now you're asking me to comment on the state of mind of someone. I can't comment on the knowledge of an individual.
Are you allowed to do so, sir? That's the question.
Are you allowed to give possession of a firearm knowing someone's going to commit an offence?
Yes, and in your presence as well.
That may well be a criminal offence.
Yes. Isn't that the reason why this particular section was incorporated, for that exact purpose that you're just referring and confirming that?
I'm sorry, I have to disagree with you, because it doesn't say anything in this particular section knowing that that person's going to commit an offence. What it does say is who is not allowed to possess it. You've got to read the entire section.
Mr. Woods, isn't it just a matter of interpretation? You interpret something, I interpret differently. We are both lawyers, reading the exact same thing and understanding it differently. Isn't that what happens in the legal profession?
Yes, I'm here to give an opinion. And then I'm also here to explain to the court what's happened in my experience.
So why do you think that your opinion is the be-all and end-all of this whole case?
I've not said that.
Your Worship, I've got no further questions for this witness.
I have no examination.
Unfortunately, I do miss things. Since I have not come across someone with such vast experience, you will forgive me to tap into your knowledge and to educate you.
Thank you, Your Worship.
Firstly, do you own a blank firearm? As you refer to a real one and a blank one. Do you own a blank one?
No.
Have you ever fired a shot with someone else's blank gun?
Yes.
And in firing, the similarities between a blank and a real?
Absolutely the same, Your Worship. And if I can just give an example, the Firearms Control Act provides for the use of what's called movie or cinematic props. Television, it's a blank firing firearm.
So just excuse me for a minute. Because walking is not doing this yet. Now, Mr. Wood, you mentioned two words now, the television and the TV movies. Are those type of blank ammunition available in South Africa readily to buy for any man on the street?
The ammunition or the firearms?
The ammunition.
Yes, it is.
Where?
It's certainly available on the internet. There are internet sales. I have a box of such ammunition. It was given to me. You can buy the firearms, the objects that discharge that ammunition over the counter as well in many, some gun shops even sell
Yes,
it.
no, I don't dispute the fact that you can buy the blank TV gun, TV movie gun, firearm, whichever you want to call it. I'm asking if the ammunition that simulates the real firearm, including muzzle flash, etc., those blanks, are they available for sale?
Your Worship, they are. And can I assist you by... There is a SAPS ballistic directive. I don't have it with me. And it relates to the definition of ammunition in the Act. If you'll just bear with me.
I don't know. Yes, I'll bear with you. You may. I've asked it, so I listen, but I'm quite aware of what the definition says of ammunition in our firearm Act.
If I may, Your Worship, a cartridge. So the definition of ammunition is a primer or complete cartridge. Cartridge means a complete object consisting of a cartridge, case, primer, propellant, and bullet or a projectile.
Yes.
So what SAPS ballistics have said is that anything that doesn't have a projectile is not ammunition, and blank ammunition falls into that category.
Okay. I understand that explanation. I'm asking that the blanks that are for sale, does it have muzzle flash or nozzle flash as is seen on TV sets,
Yes.
TV movies?
Yes,
You are certain of it.
absolutely certain.
Now, I don't have many questions. It's just quick stuff items that I would like clarity on. Nothing more, nothing less. I've marked them, so it won't take me long. I quote, you've clarified in cross-examination and you disagreed with Advocate Caesar, but I quote from what your evidence in chief says, because I've marked it. I've never seen this section used in more than 20 years or this charge to charge a person or an owner with discipline.
Responsible person.
That was not part of the evidence. I'm reading, okay? Nonetheless, so you've never dealt with the section in more than 20 years. You've never testified about the section in 20 years.
No.
So this is the first time ever you are asked to testify about section 130,
Yes.
2010, small a.
Yes.
I see. Now, you also mentioned in cross-examination, Mr. Malema was a licensed firearm holder or a competent person to...
As I understand the situation, he's not unfit
Not
to
unfit.
possess a firearm.
Are you aware of his limitations in that aspect?
I am.
And his?
I do know that he has a competency certificate.
For up to what caliber firearm?
No, it's not related to caliber, it's related to category.
And if we speak about the firearm issue that is mentioned to be the SP firearm, that is a rifle.
There are 4 categories of competency:
Yes?
handgun, rifle.
Okay, let us be clear. It's been established that under correction, please assist me, Advocate Matthews, or Advocate Holder, sorry, it involves your client, that Mr. Malema may possess up to a 9mm firearm, not a rifle.
That's not correct. It's not, competency is not related to caliber. It's related to the type of firearm.
So if you own or you are competent to possess and own a firearm up to a 9mm firearm,
Well,
you can also have a semi-automatic rifle.
you could have a semi-automatic carbine, which is a semi-automatic rifle. You could, I suppose, in theory, have a 9mm rifle. 9mm is a caliber,
No,
not a
I'm
cartridge.
speaking specifics here, not a 9mm rifle. I'm speaking about the SP firearm or rifle, which is an issue in this case, not in general, this case.
Your Worship, if I could perhaps approach it from a slightly different point of view.
Certainly?
I said that Mr. Malema is not unfit to possess a firearm.
Yes.
The reason why I said that is I know that Mr. Malema had a competency certificate.
Yes.
You cannot have a competency certificate. It doesn't matter what that competency certificate is. You cannot have a competency certificate unless you've been if you are unfit. So if you're declared unfit, then the process means that your competency certificate is cancelled.
I'm not disagreeing with you regarding competence. I'm asking you about possession of a certain type of firearm, being competent or not.
Your Worship, you can possess any firearm under the direct supervision and control of the license holder. You do not even need a competency certificate.
So in this instance, we all know Mr. Snyman was at the scene.
I don't know that, but
I'm telling you he was at the scene.
yes.
Now, the example about fidelity guards and charging the owner if one of the guards commits an unlawful act, it's ludicrous because it doesn't fit in with the facts of the case that we are dealing with now, today.
Your Worship, if you might recall, I made reference to Regulation 21 and 22.
Yes.
And the purpose of those regulations is to establish a chain of possession.
Yes.
And in order, that chain of possession is necessary in order to establish who should be in possession of that firearm
Yes.
and who is entitled to use that firearm.
Yes, I don't think that is an issue in disputing this. I think we are all in agreement on that part. There was a question asked to you by Advocate Matthews, and I'll quote the question and your answer, if you can just clarify for me. It was asked from you, in this case, who will be the responsible person? You replied there's a distinction between responsible, a responsible act, and who is a responsible person. And the person responsible is a person who it was signed out to and had the temporary permit. That is the person the police would hold accountable for any misuse of a firearm. That was your answer.
Yes.
Can you explain to me what that means?
I think, Your Worship, I think I said that the responsible person who's appointed for the company has administrative functions.
Yes.
And they're specified, particularly in the regulations. I've marked them here where the responsible person is required to complete administrative functions.
I think the administrative functions is being dealt with, and it's not an issue in this matter.
But then
the register is all balanced,
yes.
etc. It's not an issue. I'm speaking about the person the police would hold accountable.
So I've removed the responsible person from this debate because that responsible person has, for example, signed a firearm to a specific security officer, entered into the register, he has a permit. The issue of that permit means that that person who has the permit and the physical firearm is responsible for whatever happens with that firearm. If he loses that firearm, he gets charged. If he shoots someone in circumstances where it's not lawful, he gets charged, and so on.
If he leaves the firearm unattended?
He would be responsible for potentially negligently losing that firearm, yes.
And then Section 120 becomes applicable?
No, I think it would be Section 120 sub 8.
No,
that
not
would be
negligent in losing it.
It would be an offence probably in terms of one of the sub-provisions of Section 120.
We can settle on that. The only other concern that I would like you to clarify on, and this is the crux of the matter for me in this regard, is You yourself testified, you've been internationally recognized. I don't take that away from you, and I don't question your opinion in any manner. However, it is your own words when you were asked to read that section. It's extremely wide. The Act doesn't define. The Act doesn't define possession. The Act doesn't define. But you can't limit yourself to give your view based on the set of facts we are dealing with here today.
So, Your Worship, in 2022, the Constitutional Court gave a decision relating to certain provisions of the Firearms Control Act.
Mm-hmm.
And in that decision, they refer I'm guided by the legal practitioner. So in my opinion, the version postulated by the state in the formulation of the charges is neither reasonable nor businesslike in the circumstances of this case. That is my opinion.
In a nutshell, in your view, is Section 120.10a then null and void?
No.
Serves no purpose?
No, Your Worship. We all need to take into account that we can't quote the section piecemeal. It says who is not allowed in terms of this act to possess that firearm or ammunition.
Yes.
So it's linked to a very specific requirement.
Yes, exactly. I agree. So, do you have an opinion on the set of facts that you've been, I'm sure, presented with during consultation by the defense? I've not heard you on that aspect.
Your Worship, I do not know the full facts of this matter. I have not seen the video for a number of years. That was not the purpose of me being called to give evidence.
No. So that's, I'm going to leave it at that. Thank you, Mr. Woods.
Can I be excused, please, Your Worship?
No, not yet. Sorry, there's a second phase to this. Advocate Matthews, questions based on the court's questions?
Yes, thank you. I refer you to the further particulars in this matter, where the state has bound itself. These are the facts. The state has bound itself to the handing over of the firearm by accused number 2 to accused number 1. You understand that?
Yes.
All right. And I've referred you to the section 174 where worship said in the judgment that sure, there's no evidence that there is physical handing over of the firearm, but because the section says may give possession in any other manner. All right. Now, I failed to understand what other facts you've been given, the worship is asking you, to show that the firearm was handed over in any other manner. Have you been given any other facts?
No. No.
I think he was quite clear on that, Advocate Matthews, that he was not at the end of questions by court.
Anyway, the case of the worship's question is a little bit different to mine with this case. The state is bound by what it says in the further particulars that there was a physical handover of the firearm. All right.
Yes.
The fact is,
Yes.
there's no evidence as to that before this court. You understand?
I do.
Now we're going to this interpretation of this or in any other manner gives possession. And her worship in the judgment said because he was the owner of the company, all right, that means that in any other manner he gave him possession. You understand?
Can you
I do.
just refer to the page where I said he was the owner of the company? I just need to update myself as well.
Certainly.
Thank you.
Yeah, paragraph 20, page 25 of your ruling, line 19. the firearm in question being SAP 249/14 is indeed your firearm? Or the company's firearm?
The word being the owner of the firearm was not uttered by court.
The firearm in question being SAP 249/14 is indeed your firearm?
Did I use the word owner?
Or the company firearm?
Did I use the word owner?
No.
Thank you.
All right. That is the words used by the court. Your firearm. The company's firearm. Now we established that it's not his firearm. All right.
Yes.
And the firearm belongs to a close corporation, as you understand.
Yes.
All right. Now the mere fact that the owner, in brackets, might be present on a scene where somebody uses a firearm belonging to the company, would that mean that in any other manner he supplied it to?
No.
Thank you.
Thank you,
The survivor, a few questions from just to clarify, arising from the worship questions. They relate to the ammunition. And the worship asked you whether the ammunition for these blank firearms is available to buy in South Africa. Do you remember that?
Yes.
Now, what I want to put you so is that usually the blank
Correct.
you also said you don't need a license to purchase these firearms, you wouldn't need the competency to purchase a blank shooting firearm. I want to put you that the same would stand in relation to the ammunition. One doesn't need a license or competency to purchase the blank ammunition.
Well, correct. And in fact, technically, according to SAP's ballistics, it's not ammunition.
Well, that's I have an issue there, and I want to show it to you because everybody's handed in had regard to Exhibit L2, and there seems to be some uncertainty in that regard. If I may refer you to
For some reason, I don't have the last page. Mine ends at paragraph 18.
Mine also ends at paragraph 18. Does it go beyond paragraph 18?
No, I'm only up to 18, so I have this from my own thing. But if you look at paragraph 17, it's encircled for somebody, the DPPs are also view that even though the blank ammunition can technically be regarded as ammunition, in terms of the FCA, that the possession of such ammunition cannot be prosecuted based on the fact that the general public is informed that no license is necessary to possess such. So my question to you is, you said that, and I understood your definition of ammunition being ammunition that actually sends out a projectile. Here, this ammunition doesn't have a projectile, so but they say technically, even though it might fall within the definition, it's not an offence to possess it.
That's the Director of Public Prosecution's opinion. SAP's ballistics have issued a directive saying it has to have a projectile in order for it to be ammunition, to fall within the definition of cartridge as set out in the Firearms Control Act with those four components: primer, propellant, case, bullet.
Now, my next question so relates to the recent debate. If one has regard to count 6, and I'll read it to you, that's the section 120 sub 1 sub 8. You to read it in its entirety to you, and I need to tell you upfront, it only applies to accused 2, but it makes mention of accused 1, so that's why I want to make that clear. So it says here that count 6, accused 2, that the accused is guilty of the offence of contravening the provisions of section 120 sub 10 sub A, where the sections 1, 103, 121A, section 121, where the schedule 4 and section 151 of the Firearms Control Act 60 of 2000, and further read the section 157 of the Criminal Procedure Act 15 of 1977. Then they identified as providing a firearm or ammunition to any person not allowed possessing it. Now, I need to clarify this because they say further here, when they explain it in the body of the charge, With upon about the 28th of July 2018, when Adriaan assisted the quasi-stadium in Bansani in the Regional Division of Eastern Cape, the accused did unlawfully supply or in any other manner give possession of a firearm and ammunition to wit a .223 Marinka rifle and or a firearm the make of the firearm unknown to the state and a .223 Remington bullet to Julius Malema, being a person who is not allowed in terms of this act to possess that firearm and the ammunition. Now, I understood your evidence, and this is why I asked you this, to be a person who's not allowed to be, in terms of the act, in possession of the firearm and ammunition. And your reasoning is, I say, you must be a person who's been declared unfit to do so. Would that be accurate?
That's correct, yes.
Now, the reverse, or not the reverse, the facts of the case has put you where that accused number 2 has never been declared unfit to possess any type of firearm. Could that then apply on your interpretation of Section 120 to these facts in this matter?
If I understand your question correctly, and to put it in simple terms for me, are you suggesting it would be lawful for one accused to supply the other accused the firearm? Is that what your suggestion is?
I'm not suggesting. I'm using your evidence just to explain. As I understood,
I don't have the charge sheet in front of me.
I have it, please. As I understand your evidence, and this is the point, is that possession is very, very wide, and you said in order to not be allowed to possess, because I can give my firearm to somebody else to shoot, but to make it an offence, that the person that I give it to would have to have been declared unfit to possess.
No, what I said was, in these circumstances as presented to me, because Mr. Snyman was present, then he, on the version of the state, and I want to emphasize on the version of the state, could lawfully hand that firearm to anyone in his vicinity where he could exercise control over that firearm.
I understand that. My point is the following, Mr. He could hand it over to anybody, and I put to accept a person who's been declared unfit to possess such a firearm, because that person by law is not allowed to possess
Yes.
So let's use the version of the state. Okay, as was put to you. On the state's version, accused number 2, it goes against the further particular, on the state's version, accused number 2 handed over a firearm to accused number 1. Accused number 1 is not the
based on the court's questions that you could see?
Just want to, you wanted to state earlier what is the 4 type of competencies you got for different type of firearms. You said there are 4 types.
Handgun,
Yes.
shotgun, manually operated rifle,
Yes.
semi-automatic rifle, pistol caliber carbine.
Is it correct that you have to go for training to get the competency in respect of each of that type of firearms, except for the revolver and the handgun? They go for the same competency, is that correct?
Well, the training doesn't distinguish between types of firearms at all. So it's a rifle, it's a handgun, it's a shotgun, and it's a semi-automatic rifle or pistol caliber carbine. So you don't talk about a revolver or a handgun.
Yes. But the fact of the matter is they are not the same. The handgun, the competencies for the handgun and the rifle are not the same.
No, the training is different, yes.
I didn't hear your answer?
The training would be different, yes.
Correct. I did training for a handgun, a semi-automatic handgun. Can I now use that same competency certificate in respect of a rifle?
No. However, you do not need a competency certificate to use a firearm under the supervision and control of the license holder or someone authorized by the license holder.
And in the scenario, the firearm still hands it with people there.
Is probably an offense. Yes, I would agree with you.
Thank you.
Thank you, Mr. Woods. We have finalized your evidence. You are excused and you may stand up. Okay, just 1 second.
They did take him off to a clinic this morning. He suffered quite a bad cut to his head. I don't know where he is or what was the situation is with him. I'm told he's fine, but in any event, we're going to need some time just to set up everything for you.
Just before we set up and adjourn, etc., what will the basis be for bringing in a blank gun? I think we are all in agreement that it resembles the real one, as we've been referring to blank and real, that the untrained eye cannot distinguish, maybe even the trained eye. So is there any other reason that you want to present it?
The text coming with it regarding the flash. But as on video, you don't physically have to see the flash.
So it's your choice.
As long as we're all in agreement that it looks exactly like the real one.
I will hear from the state and from Advocate Odes. If that is the case, just please accept the fact that I cannot grant the permission for such. Security, our provincial security is present. Mr. Boko, the court manager, they are the people who will make a decision regarding